So under Florida statutes, generally most formal administrations should be wrapped up in about a year. And typically if that's not done within a year, then the courts are going to issue a request to the attorney and the personal representative as to why. So there'll actually be something called an order to show cause, where you'll be called before the court to explain why things are taking longer than normal. That being said, sometimes it can take a long time for some estates to be distributed, and it can be several years in some cases. Typically, the time frame for a formal administration is about 6 to 9 months if everything goes very smoothly. But then you have to also think about the IRS involvement here. And so if there's any sales of any real property or any taxable events that occurred during that year of administration, then you're actually rolling into the next year to file for any IRS documents or filings or refunds or anything else that's going to come back with the IRS. So the whole probate administration will then continue on into that year with potentially some funds held back by the personal representative or a trustee if there's a trust administration, until all the IRS matters are also resolved. In addition to the typical 6 to 9 months, I want to kind of break that down a little bit for formal administration. So when a formal administration is done, which is part of the probate process where an actual personal representative is appointed by the court, and of course the will is going to nominate that personal representative. In states outside of Florida, you may know that person as executor, but in Florida, first we submit the initial pleadings to the court, and then within about 45 to 60 days, then you have the personal representative that's going to be appointed by the court. And then after that, then the personal representative will have an opportunity to inventory the estate, and we will also submit that to the court. In the meantime, there'll also be what's called a notice to creditors that's going to occur. And that notice to creditors on its own is about a 90-day process. But that's really important 90 days, where at the end of that 90 days, if creditors have not filed a claim against the estate, for the most part, they're barred from filing a further claim against the estate. So out of 6 to 9 months, that 3-month notice to creditor period is just part of that process there. So it could be half to a third of the time just waiting for the creditor period to be done. And then there's just a discharge time and whatnot. So generally, again, for the probate administration, it's 6 to 9 months. But again, if there's some taxable events that occurred, it could be longer, just because we would have to do all the tax filings and whatnot as well with a CPA. That's a great question. And now we are going into the digital lives every which way. And so a couple of years ago, Florida enacted a Digital Assets Act as well for any assets that are in an estate. And now we're moving into an electronic wills age, where as of July 1st of 2020, we're going to have the opportunity to have electronic wills signed. So I would not be surprised if people start to see people doing their estate planning and just signing an iPad or something similar just to get all their documents done. We will not need necessarily to have paper versions of the documents past July 1st, 2020. Part of this whole new statutory change that's coming along, we will also be able to have remote witnesses and remote notaries. That's a different part of the Florida statute. In fact, the remote notary statute will be in effect as of the beginning of the year, January 1st, 2020. And so under most circumstances, there will be an opportunity for a remote notary to notarize all sorts of documents given certain procedures in place. There are two exceptions for remote notarizations. One is if there is a person that is deemed to be a vulnerable adult, and that vulnerable adult has to meet certain criteria. The notary has to ask some very specific questions of the individual to determine if they are considered vulnerable. Part of the actual process for remote notary also is going to be a set of security questions that you may have seen if you have done any credit checks, where basically the notary will ask you where you've lived in the last 5 years and give you 5 choices, and some may be accurate and some not. You've got to pass that test with an 80% proficiency to be able to have a remote notarization. And you get one extra chance at that if you fail that, and otherwise you can't do a remote notary for that document. And the other time that a remote notarization will not be available will be for powers of attorney that have superpowers. And if you've done a new durable power of attorney since October 1st, 2011, you'll recognize the 7 superpowers that the new Florida durable powers of attorney have. And for all of those, a remote notary is not going to be available. However, again, those documents can be done electronically in person because all advanced directives, whether it be a power of attorney, healthcare surrogate, living will, even a prenatal guardian, originals are not necessarily required. So electronic versions of that, and then soon, as of July 1st next year, electronic wills will be all rage. So I see that's going to be kind of the way we're going. So it'll be a really exciting time overall for electronic wills.